So we said that we would not introduce ourselves, but I have to make an exception because they think I need to say something about me, and that's because of what I've heard before. So it's important to clarify what I have done in the past and what I'm going to do in the future, especially for my friend Willem. And that's because basically I think that abroad, there is not quite the right perception about Italian litigation or how actually Italian litigation works. And President Tavassi mentioned before that we have very good judges, and I think the system itself is quite good. And of course, we will see in the slides something which I find very striking, which is that somehow the UPC system is quite similar to the Italian system if looked from a certain perspective. So what I want to say by myself, first of all, the disclaimer. Since the code of conduct, as Williams knows, is very, very strict, the first thing I have to say, whatever I'm saying today does not come from the UPC, is not endorsed by UPC, it's just my personal opinion, it's not the opinion of UPC, and is it enough? Thank you. Okay, so I said this because actually I've been a patent attorney for 25 years with the Modiano firm, and Michela Modiano is my boss, so that's why I could not stop her, even though she's like me. She likes talking a lot, and I mean, of course, now we'll have only a few minutes for my speech, but it doesn't matter, so I still have a job. And I've been a patent attorney for 25 years, and I also be a consulente tecnico d'ufficio for President Tavassi for many years, for Italian courts in general. And I want to mention this because what I'm saying now will just somehow show you how the technical judge, which, by the way, it is a dream to have been appointed as a technical judge now, because we have heard from the discussion going on between Willem, Sabine, President Tavassi, Michael, and so on, and that actually we are building a new court. And being in Budapest was something absolutely amazing, but also being in Paris in October when we had the first meeting among technical judges. It is amazing because you actually can feel the actual atmosphere of people who want they want the UPC to be a success, and we have a lot of discussion, and we are doing all we can so that the UPC is a success. And just being there and, be able to be part of that atmosphere was something absolutely fantastic. And this is just the introduction. So just going on. The first meeting we had in Paris, that was quite interesting because it was only a meeting for technical judges, so for people who really did not, in principle, do not have a very strong legal basis, apart from, of course, the IP law. We all know the IP law very well. And it was interesting because we were basically given the main expectations that are set for the UPC. And expectations were quality decision, predictable decision, and fast decision. So we say these are the keywords, they are the key points for having a successful court. And this reminding actually of what happened in Italy at the beginning of the century, because President Tavassi was mentioning that the system now works very well, and I absolutely agree with her, but it wasn't like that about, 20 years ago, because at the time, we did not have specialized sections. So I remember, for instance, driving Maria to the Court of Lodi or the Court of Mantova at, very local courts where we had no specialized judges. And of course, I remember the first thing we would do when entering a hearing was explaining the judge what a patent was, explaining what a claim was, and explaining that basically you had to map the claim on the product to decide whether there was some infringement or not. So of course, at the time, unless you were litigating the patent before the Court of Milan or some other, let's say, large courts, it would be very difficult to know how a hearing would go, because, of course, you would have to, to explain in 10 minutes exactly what a patent was and how infringement should be assessed. So in 2003, there was this, let's say, revolution, which basically was driven by the same factors which we were somehow presented in France. And I remember discussion with Mr. Modiano, who actually was one of the fathers of the Italian patent law. And basically what he said is we really need more quality, we need more predictability, and we need faster decision. The point with the local courts was that basically, since we had no specialized courts, the case was stuck among other cases, things that had nothing to do with IP or with patents. So actually what happened in 2003, we had this system created specialized judges, so judges that basically would just discuss IP cases, and they actually built a lot of experience and a lot of knowledge on patents. So the judges are now involved in IP litigation are experienced judges. We must not go there and explain what the claim is. They know exactly what they are talking about. What happened actually, what is the situation now? Well, the Italian patent judge has to know the civil law, of course. He has to know or she has to know the civil procedure. And of course, judges also have to know very well the patent law. Let's call it that. The patent law has been now, let's say, it has been collected into a single text in 2015, which is the Italian Property Code. So basically, that's what judges also know. And that, of course, is also what litigators must know. That's the most important thing. But there are also some procedural things which are quite complex, not as complex as the ones that Sabine was presenting before UPC. But further to this, the Italian judge must also understand, to the extent that is possible, the technology that is necessarily involved in patent litigation. Because when you read a patent, of course, you have to read the patent description, which is mostly technical. You have to understand the drawings. They are technical. You must understand the prior art, which means the documents which somehow tell you where the art stood before actually patent was filed. You have to be able to construe the claim, where you have to provide the claim construction so that you understand how wide the scope of protection of the patent is, or how narrow it must be interpreted based also on what was existing before the patent was filed. So it is true that patent judges must acquaint themselves with technology, but it's also true that sometimes this is not possible. I am in the electricity field. I actually quite a lot of experience also with Sabine in telecommunications cases. And for instance, in that field of technology, it is extremely difficult for a person who has not a technical background to understand how, for instance, mobile phone works, or waves, or the signals, or this kind of thing. And so it is clear that, that a judge needs some kind of technical assistant. What happens in Italy? In Italy, the judge normally appoints a consulente tecnico d'ufficio. I say this in Italian because Willem before talked about the court's expert. I think this is quite a wrong perception that I find everywhere abroad. Everybody thinks that the Italian consulente tecnico d'ufficio is a technical expert. It is not. An Italian consulente tecnico d'ufficio, which is me, who is me, I'm not an expert in the sense of I have a specific knowledge, for instance, of how a washing machine works, or about something like that. I am a patent attorney, so I understand the technology because I have a technical background, and I'm able to follow the arguments which are set forth by the party, who are assisted by technical experts and are also assisted by, of course, by the patent attorneys. And my job basically is to answer the question that the legal judge, which is the only judge in Italy, gives me, which is basically help me to understand what is the scope of protection of the patent, and help you understand whether you think there is infringement or not. So what happened in Italy is that the court expert is just a patent attorney. I am a patent attorney, and in my career I've been involved in more than 200 technical phases before the court, and only in 2 cases the technical expert, which is not an expert, was not a patent attorney. So that's basically what's happening in Italy. And if you also look at how the procedure works in Italy, this is of course a simplification, but just to get the idea. Basically, we have a legal phase where you file a writ of summons, then you have a statement of defense, and then you file your briefs under Article 183(6), which basically you collect evidence or this kind of thing, you provide witnesses and whatever. At that stage, if the parties have not asked for a technical expert, which is a consulente tecnico d'ufficio, to assist the judge because they think, well, of course, there are some technicalities here, so I think that the judge should be assisted, the judge herself can actually say, okay, I cannot really understand the technical details, I need somebody to help me. And she would appoint me, thank you, she would appoint a consulente tecnico d'ufficio saying, okay, give me some help. And when this happens, the discussion turns into a technical level, which is not really a technical level, it's a patent level, which means the expert for the court is a patent attorney, the experts for the parties are patent attorneys, so we have a written procedure, which is can also be oral, I mean, is done in writing, in which basically we discuss as you would discuss before the PO during opposition. Something like, okay, I give you my arguments, you give me your arguments, I tell you why the patent is valid, I tell you why it's not, I tell you why it is infringed, and tell you why it's not. And at the end of this procedure, then we give an opinion to the judge, so that the technical consultant or technical expert just provides an opinion to the judge. The judge, of course, is not bound by that opinion. She can change her mind if she wants, and if she does so, normally it's because she's understood the technology and she understood that the technical consultant did something correctly, maybe from a technical point of view, but did not apply, for instance, the law in the correct manner. But most of the times, the judge would confirm what the technical expert, which is the patent attorney, has.
It is important to remark, as you are ready to do, that it is not the decision of our consultant. It is the decision of the panel of judges of the specialized division. We have also the possibility to receive help by the technician in order to better knowledge the patent, to have a better comprehension of the technical aspects of the patent, but the judges must decide the case, must study the patent, and must use, if there is the case, some suggestion from the consultant, but also can compare the advice of the consultant of the parties, as is in Anglo-Saxon system, and decide the case in line with the suggestion of a consultant of one of the parties. It's not absolutely mandatory the decision, the suggestion of the appointed expert by the appointed patent attorney appointed by the court. This is just a way to study in depth the patent.
Exactly, and this is basically what I mentioned in the third block, where I say that the judge's decision takes into account, but it's not bound to the CTU's opinion.
But I'm a foreigner, yes?
Yeah.
If I make two remarks. First of all, what you do, we do as a litigator. So we make sure that the judge understands. I have always said, if my daughter of 12 years old do not understand the technology, then I'm not a good lawyer. So I translate all these difficult things for the judge. The judge doesn't need the patent attorney to understand the technical things, because that's what I, as a litigator, am doing. I have the problem of understanding. I talk to the patent attorney as long as necessary until I really understand everything, and then I know what the difficulty for the judges is, because she is a lawyer, I'm a lawyer, I don't have a technical background, I've gone through all this learning process. So if she has never heard about the periodic system of the elements, I will explain her what the periodic system of the elements are. That's one. The second thing, if I may, the second thing, what I always see when I get decisions in Italy, in 90% of the cases, the expert is followed. So we have always the impression, I'm sorry to say that the expert is tremendously important, and that I sometimes ask myself the question, is there enough criticism on the expert? Or is the judge thinking, well, it's complicated, it looks all right, and it's followed? So I have seldom seen a judge who said, I don't agree for this and this reason, and I come to this decision.
Yeah.
Sorry.
No.
No, I'm sorry, but I say I'm a foreigner. I look from the outside, and I hear this, and I say what we do in our courts as a litigator, which is doing what he does with the judge. My patent attorney educates me as a child, and then I know what their difficulties are, and I explain it to the judge, because I know I start on the same basis. And the judge then is able to make up his decision, in general.
Yeah, but if I can reply to that, it's what you say might be true, but the thing is that now we get to what the UPC system provides for, because the way you're putting this is something like, I am the litigator and I explain the judge my position, and the other litigator explains his position. The problem is that every litigator explains the position from an ex parte view. So that means that the judge does not have the possibility to understand from the technical point of view if you're telling the truth or if the other party is telling the truth in terms of technical explanation. And so that's why the judge needs some technical assistance to say, okay, he's telling me that the periodic system says this, and he's telling something quite different, or what exactly, where is the correct, meeting point between the two positions? And but if you look actually at how the UPC system is structured, I think it's not so different, because we have a written procedure to start with, and in the written procedure, normally you don't have a technical judge, because basically it's all before legal judges, and of course the parties can ask for a technical judge, but it's not necessarily appointed at the time. And again, before the interim procedure, that was the suggestion somehow that more or less the indication we are receiving is that the legal judges may decide whether they need a technical judge. But at that time, the legal judges will already have received your point of view, so the litigator's point of view. So the question which I could make to you is, why at the point would legal judges ever require a technical judges? Because you have been able to explain to them the technology, and so the system somehow will not need a technical judge. It's true that you are not obliged to appoint a technical judge, but it's also true that an Italian judge is not obliged to have a technical assistant.
Yeah, but
so.
Okay, I see your point, and sure, a litigator tells his point, but I must say that we agree as litigators on the basic of the technology. I mean, the point of difference comes somewhere when you have understood all the basic of the technology, you know how a telephone works, blah, 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 etc., etc. And then, of course, and you agree on these points. I mean, you don't start to say the periodic system of elements does not the atom, nitrogen or something like that. Of course not. We agree on all this. And only on the top point, and that's what we feel is very important, it's in the end a legal decision, infringement, yes or not. It's not a technical decision.
I agree, but...
It's a factual, but the legal, it's a legal decision, yes. Okay. You apply the law to the facts, but it's a legal decision. It's not a technical decision. And no, it's not.
Yeah,
no.
but if...
Validity also is a legal decision.
Absolutely.
Yeah, but the thing is, if I can say, I agree.
We have to...
That doesn't matter. I agree with what you're saying, and I hear what you're saying, and I've talked to dozens of US lawyers where the system is very similar, and they say the same thing, I get so educated. But the point is, if you have two fantastic litigators, one for the opponent and one for the defendant, and the judge is stuck in the middle, and here's one litigator that says extremely reasonable sounding technical things, and the other litigator that says exactly the opposite, but equally extremely reasonably sounding. How do you decide? This is what Alessandro is saying. Sorry.
No, thank you.
Then you are a judge, and what do you do as a judge? You say, well, that's extremely good. I don't know, they ask a patent attorney.
Exactly.
No, but it's not like that. No.
I asked the technician give me some other technical elements in order to form my decision, in order to... But I think that are two different ways to deal with the case. One is better, in my opinion, but the solution adopted by the UPC court is perfect. The judge, the technical judge, inside the court is something similar. I agree with Alessandro. And is something similar to our experience, is a solution, a good solution for everybody.
And
but he is different because he has a vote. I mean,
yeah, that's basically what I was saying here. Yeah, but again,
that's very important.
I will come to that now, because the thing is here it says that the TQJ, the technically qualified judge, takes part in the decision, which is very different from. But what happens actually if you go further? Next step. In any event, what we notice is that technically qualified judges, if present, are always at minority. So what means is that basically, if we are in the first instance, we have 3 legal judges, okay, we might have a technical judge. According to William, probably we don't need it, but hopefully you will need some technical judge at a certain point. Otherwise.
No, sorry, you know that normally normally you will have also
Yeah.
a revocation action, validity,
Yeah, sure.
and there is always a technical judge.
Yeah, but probably you would, my question would be, in case of revocation action, do you think that you would be necessary
If
to
I
have-
would have made a UPC, there will be no technical judges.
Okay, it was, I think so, I got it.
I'm honest about it.
Okay, so what I was just going to present in this slide, it was basically, it is true that technical judges before the UPC actually take part in the decision, but in any event, if legal judges all disagree with a technical judge, or at least they don't follow the technical judge, the legal judges will always win all the time, because there's no possibility that the panel comprises more technical judges than legal judges. This is different, for instance, from the Bundespatenggericht in Germany, where in appeal cases you get more technical judges. And this is another slide which is quite interesting, I think, because, Willem, of course, was the president of the advisory committee. So basically, he somehow, I think, he guided the way that candidates were selected as technical judges, I guess. So, so we just said that the candidates, basically, or the ideal candidate, should be a person with a strong technical background, a strong knowledge of the patent law, familiar with patent litigation, because these were the requirements which were presented when actually we made the application. And in my opinion, must be a valuable aid for legally qualified judges to understand the technical aspects of the case better and quicker. And such person is the consulente tecnico d'ufficio in Italy, and I think it is the technical judge in the UPC. And that's why I was presenting myself before, because now I have both roles. So I can be a technical expert for the court, Italian court, I can be a technical judge.
The best candidates were the Italian candidates, to be honest.
Right.
Because, no, I'm not saying that because I'm in Italy, because you, very often the candidates had experience in litigation, both with respect to infringement and validity questions in legal proceedings. So that's kind of ideal profile for a technical judge. It's not because you're Italian, but because of your experience, which is, of course, a very different experience of, for instance, a Dutch patent attorney who never plays this type of role.
Yeah, I agree on that, of course. And of course, no, I say this because we are 7 technical judges appointed from Italy, and all of us are technical experts for the court or consulente tecnico d'ufficio, and I know all of them, and they're all absolutely top, let's say, both litigators and patent attorneys.
Good language skills.
And yeah, also well, reasonable, let's say, at least. And but if you actually look at the technical judges who have been appointed by the UPC, you can see that 35 plus 8, which means 43 out of 51 are actually European patent attorneys. 35 of them come from private practice, and 8 of them are in-house patent attorneys. And there is another eight technical judges, and they are either judges, for instance, from the German courts, where they already had this kind of role, or are EPO members who basically applied for the position. Yes. Another interesting thing is actually the UPC comprises several countries. It's 17 countries now, it's going to 25 and whatever. But only the technical judges come only from 8 countries. And I think that, again, this is somehow reflects the fact that in some countries, litigation is closer to the way the UPC system is structured, even though, of course, it's different, and which probably plays a role has played a role in the selection of candidates. So we have 15 from Germany and 13 from France, and then Italy is the third one with 7 candidates, successful candidates. Right, so this is just a final slide just to let's say, summarize what we say. So basically, I think that the role of a technical judge is something like, it's similar to what we are doing in our own jurisdiction, which is we need to help the legal judges on technical facts. Of course, we have a voting right, so our vote counts. Of course, as far as the legal aspect, the specific legal aspects are concerned, I think the legal judges will have, of course, a different mindset or a better mindset to discuss about procedural things like the one that Sabine was illustrating before, because of course it's very nice and very interesting to understand whether we should stay a case rather than not, but probably that's not the role which is expected from a technical judge. And all in all, just for Italian lawyers or Italian clients, I think that all Italian lawyers will somehow feel at home also before UPC. And if they don't feel at home in any case, litigation before Italian courts is still a good option. The system works well, and so we can also do this. And I just one last slide, which mentions what Williams was saying before. There's a problem with the fact that a technical judge, normally, I mean, most of them are top IP litigators. And basically what happens is, if we are technical judges, can we represent the clients before the court? I have to say that that letter which he mentioned before, because this is something very important. The fact of representing clients before the court and being a technical judge is something that very few of us would consider. So I myself, as a patent attorney, I would never represent the client before the court, even if I was not a technical judge. And that's because I think we need a lawyer. We need a lawyer because the lawyer is the one that who basically understand the real, paths of the law and whatever. So that's one thing. The second thing is, would I feel comfortable in appearing at a court where, let's say, a colleague of mine is at the other side of the bench? And I think I would say probably not. I mean, this is something which happens all the time in Italy, because when I'm not, let's say, a technical consultant for the court, I'm a technical consultant for the party, but the technical consultant for the court is a colleague of mine, and we all know each other, so that's one thing. But I think that the perception that you might give if you do this before the court is something that actually is not good for the court. So I think I agree on that. What really concerns most of the attorneys who signed that letter he was mentioning is actually the strict rules that are being put in place about where you have a conflict of interest. Because one of the rules says that, for instance, if one of the parties has a place of address at your office, then you cannot be at the other side of the bench. But we are patent attorneys. What do patent attorneys do? They work for patent attorney firms. And what do patent attorney firms do? They file patents, they file validation, they do a lot of things where most of the time attorneys are not even involved. For instance, Modiano files something like 5,000 translations a year. And I have no idea who actually these translations, the name of whom they are. So the thing is, according to the current code of conduct, as we understand it, if we have something like a place of address of somebody, let's say, who is in somewhere in China, and my colleague in Munich has filed a translation, then I would have a conflict of interest. This is something that, for instance, the Italian case does not apply. It has been decided that basically, when it's just formal activity, this does not rise to conflict of interest. But the way we read the code of conduct, it is conflict of interest. So the thing is, and that was somehow the purpose of the letter, we need to find some kind of a balance so that technical judges can be technical judges, because and I think that the reason that William was mentioning for an additional call for technical judges is probably that they understand that in many, many cases, all judges will have a conflict of interest. And so probably we need a larger pool. Of course, the solution would be ideally to have full-time technical judges. And I'm not saying this because I want to leave my Modiano firm, but just because that would be the obvious solution. So basically, somehow you would have people who
after
really...
your retirement.
Right. So in 14 years, I will and this is basically the end of my presentation. So thank you, everybody.